Just going to give it another couple of minutes and then we'll get going. Just going to give it one more minute for folks to log in and then we'll get going. All right, it's a couple minutes after. I think we'll get going with this session today. So thank you all for attending this session, Planning Ethics. It's at the 2021 Joint Planning Conference hosted by the New York Upstate Chapter of the American Planning Association and the New York Planning Federation. My name is Mark Castiglione. I'm reprising my role as host and moderator today for this ethics panel. And so I'm excited to be part of this panel as well. Before we get started, a little housekeeping and notes of appreciation. We'd like to thank our conference premier sponsors, Hodgson and Russ, and the session sponsor for this ethics session, Labella. Without our partners, this conference would not be possible. We want to let you know that all our sessions are going to be recorded and available through the conference Eventbrite page. Videos will be posted, PowerPoint decks will be posted as soon as they become available. I'll enter the CM number for certified planners in the chat box. Planning and zoning board members may be eligible to receive credits from watching recorded sessions. It all depends on what your individual municipality allows. For our conference here, the AICP planners can claim CM credit hours by viewing recorded sessions on the conference webpage. All attendees are automatically muted when they enter the webinar. If you have questions, please add them to the Q&A box. We'll address them. We'll try our very best to address them on the fly as they're relevant to the topic that's being discussed. Like I said, I'll provide the CM number in the chat. All registrants will receive an email confirming their attendance at this session 24 hours after the session starts. This email is suitable for presentation to your local board for planning and zoning board member training credit. Our session today will provide an overview of ethical obligations of planners. Given our audience of planning professionals, planning and zoning board members, the content will provide a brief orientation particular to the ethical obligations of planners who are members of the American Planning Association, planners who are certified by the American Institute of Certified Planners, and obligations of planning and zoning board members related to public officers law or open meetings law. There are a lot of overlap between all of these ethical obligations, so we hope each section will be beneficial to all. The bulk of today's session will go over real-world scenarios and apply related ethical standards. I'm pleased, while I will be providing some ethical orientation for our AICP and APA members at the beginning of our talk today, the bulk of the presentation for the majority of our audience here will be presented by Robert Stout. Robert is a partner with the law firm of Whiteman, Osterman Hanna. He advises clients on all aspects of environmental and land use law. His practice extends to representing towns, town planning boards of appeals, municipal zoning and planning, on municipal planning and zoning matters. He's been committed to public service throughout his career, and on numerous occasions he's been recognized for his skills and talents, including as a rising star by the Super Lawyer magazine in both New York State as well as New Jersey. He received his JD with honors from with a certificate in environmental law from Pace University School of Law, where he served as editor-in-chief of the Pace Environmental Law Review with famed land use attorney John Nolan, might I add. So we're in good hands in this session. So without any further ado, I'm going to stop sharing this slide and start sharing my other presentation slide. I can minimize this. Thank you for your patience. All right, step 1 and step 2. Okay, can everyone see that, my screen? Robert, can you see it?
Yes, I can.
Great, thanks so much. So I just wanted to take a moment to provide a brief overview of some ethical considerations that apply to members of the American Planning Association and the American Institute of Certified Planners. Both entities promulgate ethics rules and obligations for their members. So a disclaimer related to the conversation about the AICP Ethics Code in particular. All certified planners should be aware that the only arbiter of ethics complaints or questions is the AICP Ethics Committee. They're the only body vested with the authority to address those questions. If you have any questions about the ethical scenarios, or if you have any issues about a fellow planner or other member and their performance, you're advised to seek informal opinions from the AICP ethics officer using the contact information on the slide. Overall, all members of the American Planning Association, and this is also applicable to, I think it's applicable to a certain extent to planning and zoning board members, because they have a certain comfort when hiring planners who are members of the American Planning Association and also certified planners from the American Institute of Certified Planners, knowing that they're held to a high standard, high ethical standard. For members of the American Planning Association, ethical guidelines dictate that we all serve in the public interest. And, what does that mean for planners? Is that we are obligated to provide accurate information, provide opportunity for all to engage in the planning process. We pledge to work to protect the natural and built environment, and we pay attention to the long-term consequences of our decision-making. Again, APA members are obliged to maintain high ethical standards of integrity and proficiency. We are to disclose any conflicts of interest. We need to avoid all gifts and favors. We have similar rules that planning and zoning board members are under from the public officers law in terms of conflicts of interest and appearances of conflicts of interest. And we must also pledge to improve planning competence. And this is contributing our time and tutelage to planning boards and other planning groups so that they can become more proficient and understanding of the general principles of the practice of planning. For members of the American Institute of Certified Planners, a certified planner is the gold standard when it comes to planning proficiency and prowess in the planning profession. So all of you planning and zoning board members, it is advantageous for you to hire and employ certified planners in your municipalities, or engage firms that hire certified planners because you know that there will be a certain high standard and ethical obligation for those planners. And in particular, you should be comforted with the fact that each planner who is certified must maintain their certification through continuing education, and that includes 32 hours every 2 years of continuing education credits. So contrasting that with planning and zoning board members, 4 hours annually, it's a substantial obligation to training and continuing education that certified planners come with. And you can rest assured that they bring to the table a lot of experience and knowledge. So just really quickly, the AICP Code of Ethics, just to touch on its general overview and buckets and categories. We have aspirational principles. These aspirational principles have a lot of overlap between what Robert is going to be talking about later that apply to planning and zoning board members and the applicable rules for public officers. Rules of conduct. These are things that certified planners shall not do. Advisory opinions. These are things that are spelled out into the AICP Code of Ethics that you can certainly look up if there are any questions about an ethical behavior, any questions about a scenario that you're uncomfortable with. You can often look at the advisory opinions promulgated by the AICP ethics officer to provide guidance in that regard. Complaints of misconduct, that procedure is also outlined in the AICP Code of Ethics, and how matters of discipline are handled by the AICP Ethics Committee and how they're sort of adjudicated within that body. So the aspirational principles in the AICP Code of Ethics, again, similar to the American Planning Association, certified planners, our responsibility is to the public. We must consider the interrelatedness of decisions. We must prioritize broad participation in the planning process. We must advocate for social justice, not only in terms of participation, but in terms of outcomes to public policy. And we must maintain fair dealing in front of the planning process. Everyone is equal under the planning process. We maintain a responsibility to our employers and clients. We must maintain independent judgment. We must accept the decisions of our clients or employers and avoid conflicts of interest, which also includes taking contrary positions to our employers and clients. And we also have a professional obligation to our profession and to our colleagues. We must strive to contribute to planning knowledge, participating in conferences like these, participate in volunteer activities, including becoming members of planning and zoning boards of appeals, or other organizations and community boards that influence the development and growth of our communities. Certified planners are under a variety of rules that dictate what we shall not do. And these are very similar to the things that planning and zoning board members need to strive to avoid as well. Abusing our position, avoiding conflicts of interest, making false or deceptive statements. We are obligated to be objective and present information factually. Honest and fair dealing. Everyone is equal under the planning process. Nobody gets an advantage. Nobody should be disadvantaged. Legal and ethical responsibilities. We have a loyalty to our employer. We're not supposed to take opposing viewpoints unless there's a significant issue with that. We have to maintain the confidentiality of private communications and avoid private communications when they are on their face unethical or illegal. And obviously respect confidentiality with our positions and the review process that we have. So this is just a snapshot of the buckets of ethical cases that were brought before the AICP Code of Ethics in 2020. 8 cases were dismissed with no charges filed. 6 cases were dismissed after a preliminary review of those cases and the findings of fact. 4 cases were settled, and agreements were reached that the misuses resulted in the loss of the AICP credential for that member, and 2 disciplinary actions were issued: a 1-year suspension for wrongful conduct, and the other a confidential letter of admonition to the member for wrongful conduct. This is the sort of distribution of complaint types that are issued, that were issued in 2020. And that shows you the kinds of hot topics that planning ethics generates among professional planners in the United States. I will make the case for our AICP planners to take a deeper dive into ethical considerations particular to AICP planners by watching a YouTube video on the AICP cases of the year. And I'm going to paste that link in the chat box right now. It is a very comprehensive presentation. And I just pasted it to Andy Rouse and not everyone. So let me just paste it to everyone. It's a very comprehensive presentation on the ins and outs and scenario and real world scenarios that the AICP Ethics Committee had to wrestle with over the past year. It's presented by the Ohio chapter and available to New York Upstate Planning Association members for additional ethics training credits. So I'm sure all the lay planners in the audience are now bored to tears with the review of all the obligations of us professional planners and the high standards that we're held up to. So I know everyone's enthusiastic now to hear from Robert Stout about the overall obligations of planning and zoning board members and planning ethical obligations. So Robert, I'll turn it over to you.
Sure, we'll make sure that everyone's bored to tears now, not just one segment of our audience. Bear with me here as I bring up my screen. And get a phone call at a very inopportune time. Okay. Well, thank you, Mark. Thank you, everyone, for joining us today. First, I think I just want to thank everyone for not only for being here, but for serving in your role as a public official to the extent we have ZBA and planning board members here. I think it's always a thankless task. I think it's even more of a thankless task in the current environment a lot of us are operating in. It's not easy for municipal officials out there. It's certainly not easy for local municipal officials who are dealing with things in their neighborhood and passing judgment on applications and matters that their neighbors are bringing before them. And certainly operating now in a world of social media where somebody can comment and offer their opinion on what you did nearly instantaneously, it's a challenging environment unlike any we've ever seen before for local officials. So thank you. Thank you for what you do, because our communities would not function without that. That said, I think it's a nice segue into talking about ethics, because unfortunately, when everyone's under greater scrutiny, then ethical allegations are often the low-hanging fruit, for lack of a better term, for somebody who's upset with a decision that a board member made or a particular perspective that a board member has. There might be the thought that they can get the biggest bang for their buck in challenging somebody by questioning their ethics. I'm sure everyone on this call, and including myself, believes their personal ethics are beyond reproach, and I'm sure that's true for all of us. One thing to bear in mind, though, is to not even give the appearance of impropriety, much like the principles that Mark was talking about, that professional planners hold themselves to. So while we think we are always making ethical decisions and we're guided by our conscience, we periodically need to refresh ourselves on the rules, and not only the black letter rules, but also the guiding principles that go into making decisions. So I'd like to start with a discussion, not necessarily of the black letter law as to what the general municipal law requires and what your local municipal code of ethics requires, but at a higher level, discussing the ethical obligations and fiduciary duties of public employees. Reading through the cases, reading through the opinions of the Attorney General, reading through the opinions of the Comptroller's Office, you frequently see decisions be overturned or decisions turn on whether or not there was an appearance of impropriety rather than an actual violation of a standard. So the fiduciary duty is one that all public employees, much like professional planners, are bound by. Fiduciary duty of loyalty and care, oversight and accountability, and disclosure in certain instances. What is a fiduciary duty? It's an obligation to act in the best interest of another party. In this case, in the case of a public employee, that other party is the public. It's upholding a position of trust, and you're really prohibited from acting in a manner that's contrary to the best interest of the public in this instance. As a municipal official, how do you determine what is in the municipality's best interests? You look to the enabling legislation, that is the statute that guides the review that you're doing to provide a standard. For example, a zoning board of appeals, considering an area variance application, you look to what the standards of the balancing test are. That is that the benefits conferred to the applicant are not outweighed by the detriment that's visited upon the community by the decision to create a framework within which your decision is made. You look to the town's mission and you look to any applicable ethical standards. Who do you listen to? Homeowners, developers, you have competing factions who are competing for your attention. Who do you listen to in order to understand? You have constituents, ratepayers, politicians, contractors, whomever is going to be appearing before you, and you have members of the public who will be commenting on the applications before you. You have an obligation to listen to all of them. You have an obligation to take into consideration all of the public comments you receive during a public comment period. But at the end of the day, the responsibility to uphold your fiduciary duty lies with yourself, and you're the one who's obliged to exercise discretion. The framework within which I'd like to see board members operate, they need to be making informed decisions. What is making an informed decision? That's asking questions when it's appropriate to ask questions. You can't defer. You can't defer to the opinion of the attorney that's representing your board. You can't defer to the opinion of the professional engineer who's working with the board. But you have an obligation to consult with those individuals to obtain advice, facts, and analysis from them. So it's a delicate balance of making sure you're adequately informed by those professionals, but not ceding authority to them to make decisions for you, because at the end of the day, it is the board member's responsibility to be making those decisions. You have a duty to inquire, not only of the applicants, but of those professionals, of the applicant's professionals, as well as the board's professionals, and a duty to seek expert guidance in any new area that you might not be familiar with. If you miss a meeting, I've seen board members seek to recuse themselves if they felt like they missed too many meetings while an application was being considered and therefore can't render an opinion on an application. I don't think that's appropriate to do. I think the obligation is on the board member who missed several meetings to familiarize themselves with the minutes from those meetings, talk to other board members in a public setting to learn from them what was discussed at previous meetings, and render a decision on the application based on all the information that's part of the record. When you recuse yourself from an application in a scenario where recusal is either not required or warranted, to the extent that any planning board application requires a majority of all members of the board to vote in favor of it, having a board member recuse themselves for an unnecessary or inappropriate reason damages the ability of the applicant to reach that majority of all members. Independence is the foundation of fiduciary duty. You make decisions for yourself and nobody else. If your judgment could be influenced by an outside factor, then you can't appropriately exercise your fiduciary duty. So you have to resist the influence to be unduly influenced by outside factors. How do you ensure that you're independent? You can't use your position for gain for yourself or anyone close to you. I think that goes without stating, but it's a question that you always have to ask yourself. You can't disclose confidential information. Oftentimes in the context of evaluating an application, you might receive material that's submitted under a claim of confidentiality that is an exemption from the Freedom of Information Law, be it business confidential information or some other statutory right to confidentiality that an applicant has, that has to be maintained. That has to be upheld. You can't use that confidential information for your own purposes, and you also can't disclose that confidential information. We'll get into more detail about having an interest in any business or activity, but you can't have a business or activity which stands to gain or has a conflict with the town. And at the end of the day, while there are rules and principles that guide us, it's an issue of common sense in many matters. So let me check the chat here to see if we have any questions or Q&As. See, we have no questions at the moment. So, well, actually, there was one that appeared to be answered. Oh, Mark's jumped ahead of me and answered some of these. I see the question that should real estate professionals be allowed to be members of planning boards? And Mark points out that the only prohibition is on legislative body members. Legislative body members are not eligible. No person who is a member of the legislative body of the city to which the provisions of this section are applicable shall be eligible for membership on such planning board. That's absolutely true. The only thing I would add to that is that if a real estate professional, let's say, is a residential real estate broker who does a fair amount of business in a particular town or village and is also on the planning board, then it's extremely unlikely, I think, that residential real estate broker would face multiple scenarios where they would have to recuse themselves from considering a matter before the planning board because their client had an interest in the matter before the planning board. That said, I could see a scenario where somebody maybe who's a commercial real estate broker or other type of real estate professional who is more actively involved in projects that do require site plan review or other approvals, special use permits from a planning board, that could potentially be presented with the need to recuse themselves on a frequent basis before board. And if somebody believes that they cannot discharge their obligations as a member of the planning board because they will more often than not or frequently have to recuse themselves from matters, then they probably shouldn't be on the planning board. So while that's not a bright line prohibition of a real estate professional from being on a planning board, every situation is unique. The role of every real estate professional is unique within the town. And that person should ask themselves if, based on the nature of their work, they foresee circumstances in which they would have to frequently recuse themselves from matters before the board because of their involvement. And if the answer is yes, they probably should not be on the board. So that was a good example of how to kind of evaluate one particular scenario. Mark gave a disclaimer at the beginning of his presentation. I should do the same. Every situation we consider is going to be highly fact specific, and every municipality's code of ethics that they adopt is also going to be different. So our intent today is to talk about how to review issues and what the guiding principles of those reviews are, not to give any specific advice on any particular scenario, because every scenario is going to be fact specific and the rules that apply different based on which municipality you're in. For any fact specific questions about your municipality or particular scenario, the best thing to do is to consult the attorney for your board, or if your municipality has a municipal board of ethics, which board of ethics is charged with rendering advisory opinions, you could submit a request for an advisory opinion to that municipal board of ethics or a comparable county board of ethics, depending on where you are. So identifying and avoiding conflicts of interest. Ethical purposes generally protect the public from non-compliance and maintain public trust in government. GML Article 18, which is the main state law governing municipal ethics, really focuses on conflicts of interest that prohibit municipal officers and employees from having an interest in a contract with the municipality over which they have control. So the next few slides, we'll discuss GML 18 and this concept that municipal officers and employees, of which planning board and zoning board members are, cannot have interests in contracts. With respect to municipal codes of ethics, which you heard me reference already, state law requires that every municipality have a code of ethics that is at least as stringent as GML Article 18. In almost all instances, they are more stringent, and they should be more stringent. Because we have people from all over the state in this session, we won't be evaluating any one particular municipal code of ethics, but I have taken snippets from the model code of ethics that has been published, which serves as a baseline for municipalities to consider. Its elements aren't required, so your code might or might not have some of the provisions in it that we will discuss, but it's a good baseline. And certainly to the extent that you are a board member in a municipality that for whatever reason does not have a municipal code of ethics, or one that's been on the shelf for far too long, make sure you discuss that with your governing board, your town board, or your village board of trustees in order to ensure that they're complying with their obligations to have a code of ethics on the books. Article 18, as I mentioned, regulates conflicts of interest by prohibiting officers and employees from having an interest in a contract. We'll go through the exemptions, which provide more detail as to what the underlying standard is, but generally a municipal officer or employee is prohibited from having an interest in a contract when that person has certain official powers or duties related to the contract. Generally a 5-step analysis for determining if a conflict exists. The first question is the individual a municipal officer or employee. In the case of planning board and zoning board members, the answer will be yes. Is there a contract with the municipality that's broadly defined? We'll get to that in a moment. Does the officer or employee have an interest in the contract? 4, does the officer or employee have the requisite power or duty under Section 801, which is essentially the power or duty to approve or enter contracts? And 5, do any of the exemptions apply? If elements 1 through 4 are satisfied and none of the exemptions apply, then the contract is prohibited. If one or more of the exceptions apply, then the contract is not prohibited, but disclosure might be required under 803 and potentially a recusal. Conflicts of interest prohibited. A municipal official cannot have an interest in any contract with the municipality if they have the power or duty to negotiate, prepare, or authorize or approve the contract. This is probably not something that a zoning or board member or a planning board member would come across. Audit bills or claims under the contract, or appoint an officer or employee has powers or duties to audit or negotiate the contract. It's the mere existence, though, of those powers that give rise to a potential interest in the contract. So to the extent that you want to determine as to whether or not your position involves negotiating, preparing, or authorizing contracts or auditing bills, you have to check the enactment that created the position within your town code, or the authorizing resolution that appointed you to the position. An interest is defined quite broadly to be a direct or indirect pecuniary or material benefit accruing to an officer or employee as a result of the contract with the municipality which the officer or employee serves. It's important to note that by statute, a municipal officer or employee shall be deemed to have an interest in the contract of your spouse, minor children and dependents, except when a contract of employment with the municipality with such officer or employee serves, a firm, partnership, or association of which such officer or employee is a member or employee. So if your company has a contract with the town, then you're deemed to have an interest in the contract. And unless an exemption applies, that contract would be prohibited. C, a corporation of which such officer or employee is an officer, director, or employee. And D, a corporation, any stock of which is owned or controlled directly or indirectly by such officer or employee.
Hey, Rob, we have a question that's related to the content here.
Sure, shoot.
So Rich Scavo asked a question. If a member of a county planning board is a code enforcement officer for a municipality in that county, should they recuse themselves from voting on any application from that municipality that comes to the county planning board?
That's a good question. Well, I think it's a facts and circumstance of each application that comes before them, because that code enforcement officer who sits on the county planning board doesn't necessarily have an interest in the application that's being presented to the county planning board. His role or her role is to evaluate the technical sufficiency of the documents and essentially conclude whether or not they comply with the state building code and whether a building permit can be issued. Whereas the role that the county planning board is fulfilling on a GML referral is to determine whether or not the project as proposed has the potential for any county-wide or intercommunity impacts. So I don't necessarily see an inherent conflict there just off the top of my head, because the county planning board isn't reviewing the same substantive decision that a code enforcement officer made. They're looking at two different things. Perhaps if there were a scenario where there was an issue with building code compliance, or if there was a pending appeal of a code enforcement officer's determination that would change the facts, there might be a unique scenario that would require recusal. But as a general rule, I don't see an incompatibility of office issue there.
One more question that's related to some content that you presented earlier.
Okay.
From Lynn Fields. When you were discussing the agency relationships, does that also mean implied agency?
Could I get some clarity if maybe you could unmute the person who answered
Sure.
that question?
Let me unmute Lynn. Hopefully he's got. So I'm asking you to unmute Lynn. There you go.
Hi. I'm sorry about my dog. I'm a real estate educator and have been for over 40 years. My question has to do with implied agency. I understand fiduciary concepts, that's not a problem. Is there an implied agency when you're dealing with being a member of a planning board or zoning board of appeals?
In what sense? An implied agency on behalf of a certain entity?
No, that's okay. Agency relationships, as we're aware of, actually deals with us as the agent to the principal, which would be the planning board or the city councilors. Is there such a thing as an implied agency when we sit on a planning board, or do we just have a general agency with them? I'm just kind of curious as to where we would stand in that whole agency concept. I understand fiduciary responsibilities lie with any agency concept, but I was just curious if you have that kind of situation happen.
And frankly, I'm not familiar enough with implied agency to be able to tell you if I think there is. In my experience, I've always viewed this as a role of fiduciary obligation. You're fiduciary of the public. As to whether or not you're an agent of the board, offhand, I wouldn't be able to tell you. I'm sorry.
Okay, no, that's fine. Thank you for your time. I appreciate it. It's great.
Thank you, Lynn. I appreciate the question. So exceptions under state law. Actually, Mark, do we have any more comments that?
Just check. I have all the windows open right now. Somebody asked or commented in previous ethics training, they've been instructed that a municipality may not engage the services of any consultant in their firm where the result of such a contract would have a financial benefit to an elected official. For example, they can't hire the board member's accounting firm, buy cars from the mayor's dealership, etc. One example given was actually having to terminate a contract with an accounting firm when the supervisor's spouse began working there. Is this your interpretation as well?
Yes, I think that's right, because again, courts have stated that even the appearance of an impropriety is an impermissible relationship. So based on your description of events there, I could see how somebody could perceive that to be improper and therefore inappropriate.
No more questions at this point.
Okay, thank you, Mark.
Yep.
So exceptions to the prohibition on having an interest in a contract. So where the interest is prohibited solely because of the position within the municipality, an exception exists where your pay as an employee of the firm will not be directly affected by the position, and your duties as an employee of the firm do not directly involve the procurement, preparation, or performance of a contract. That said, this also skates very closely to the line of there being a perception issue, and courts have found that notwithstanding there being no violation of Section 801, it's possible that the contract would be prohibited. Designating a newspaper for the publication of any notice, resolution, ordinance, or other proceeding where such publication is required or authorized by law is not a interest in a contract. A contract in which you have an interest in, if the contract was entered into before you were elected or appointed, but no renewals of the contract, so no decision is being made with respect to the contract. A contract with a corporation in which you are the stockholder, so long as your interest is less than 5%. And a contract, if you have an interest in the total value, does not exceed $750 in a fiscal year. Advancing slide is a little slow here. Sale of property in municipality needs approval. Acquisition of real property by eminent domain is an exception. A contract with a not-for-profit, where a member of the governing body or board is elected and serves without salary. Purchases or public work is approved by resolution of the body or board by the affirmative vote of each member of the body or board, except the interested member who shall abstain. So to the extent that the work needs to be approved by an entire board and the interested member abstains, there would be an exception to the prohibition in the contract. Other exceptions, other than what is specifically laid out in the statute, there are not other exemptions. The comptroller's office has been quite strict in their view and identifying scenarios that are the subject of inquiry, regardless of whether or not there's a competitive bidding requirement, disclosure requirements, abstention or recusal or emergencies. These are not exemptions. If it's not spelled out in the statute, it's not an exemption. Also referred to the model code, section 4, or the specifics of your individual municipality's code. There's a prohibition on the use of a municipal position for personal gain or private gain, which could be viewed as broader than the prohibition of having an interest in contracts. No municipal officer or employee shall use his or her municipal position or official powers and duties to secure a financial or material benefit for himself or herself, a relative, or any private organization in which he or she is deemed to have an interest. So this is quite a broad catch-all. Again, the model code and municipal codes may go further than the general municipal law. And this broad prohibition on using a municipal position for personal gain does that. My advice, whenever you're presented with an issue that you think could even potentially result in private gain, personal gain, that's a gut decision. That's something you feel in your stomach as well. Maybe I need to think this through. And to the extent you need to think it through, you pause, you consider, you ask yourself if there is a benefit. Chances are, if you feel you have to go through that process, then it's a situation you should be avoiding. Model code also contains a recusal and abstention requirement. No municipal officer or employee may participate in any decision or take any official action with respect to any matter requiring the exercise of discretion, including discussing the matter and voting on it, when he or she knows or has reason to know that the action could confer a direct or indirect financial or material benefit on himself or herself, a relative, or any private organization in which he or she is deemed to have an interest. So recusals and abstentions are appropriate when you feel that you might have a benefit or a relative might have a benefit. Recusal and abstention, though, are not exemptions to the prohibition against having a conflict of interest. They should be followed when the conflict is otherwise permitted to exist because of an exemption in state law. One example here, a member of a board of fire commissioners of a district within a county of more than 200,000 people, who is an officer and owner of 1/3 of the stock of a corporation, would have a prohibited interest in a contract for snow plowing and lawn maintenance between the district and the corporation, even if the fire district solicits bids for the work. The corporation is the sole bidder. The commissioner recuses himself from discussions about the contract and abstains from voting on matters relating to it, that being because there is no exemption from the prohibition of having an interest in a contract in municipalities within a county having more than 200,000 people.
Here's a related question, Rob.
Yeah.
I hope I get this one right. It says, does someone who works for a local real estate agency have a conflict or perception of one if his agency brokers, but not the planning board member, becomes a sales agent for an approved subdivision? And actually, this would have been something that was set up ahead of time. And should they have recused? I would hate to think that after the approval, the contractor then went to that agency. So I think the first part of this is really the relevant part. If a local real estate agency has a conflict or perception of a conflict, if one of their brokers, but not a planning board member, becomes a sales agent for an approved subdivision.
Yeah, if the relationship arises after the subdivision is approved, I see less of an issue. If the relationship arises prior to it, I think that would be a prohibited relationship. Anything else, Mark?
No, it sounds like you have some sort of Darth Vader issue going on right now.
I do.
Yes.
Let me try to. Is this any better?
It still sounds a bit garbled. So what I'm going to do is mute myself and then unmute and then see if that.
Test. How is this? Are you getting an echo now, Mark?
It still sounds weirdly garbled.
Huh. I am not doing anything. Not doing anything different on my end. I can log in and log out if it's being that disruptive now and see if that helps anything.
It is quite disruptive. So I think it would be good if you try to log in and log out.
I apologize for that. Let me do that right now.
I apologize for not having hold music.
Mark, can you hear me?
Oh, it's like angels,
Oh,
like a chorus of angels. Sounds brilliant.
That's the first time anyone's ever said anything like that about my voice, but so thank you. Let me bring back my screen and get going again here.
And Rob, can you start your answer to the previous question about the real estate agent?
Oh, sure. Let me. I see that because I logged out, that question disappeared. Can you just read that to me one more time, Mark, if it's still available on your screen?
Sure. Does someone who works for a local real estate agency have a conflict or perception of one if his agency brokers, not the planning board member, becomes the sales agent for an approved subdivision?
To the extent that the relationship with the agency arose after the subdivision was approved, I don't think there's an issue. If there was a contract entered before the subdivision was approved and that individual board member stood to gain financially from the arrangement, then yes, I see that as a problematic contract.
Another question from Janet Anderson. I own stock in a mutual fund that includes an electric stock in it, and the municipality gets its electricity from that provider. Would I be prohibited from being on the board? My non-lawyerly take is that no, you just have to disclose your investment portfolio. But.
Right, and that's one of the exceptions. I just went back, a contract with a corporation in which you are a stockholder, so long as your interest in that corporation is less than 5% of the outstanding stock. So, not an issue. Okay, recusals. What happens when one recuses? So if the model code prohibits a municipal officer or employee from exercising, performing a power or duty, then that power or duty is simply exercised by the other members of the board. If the power or duty, is vested in an officer or, municipal officer individually, then the power or duty shall be exercised or performed by his or her deputy. So obviously for board members, number one is what's relevant here. Recapping, conflict analysis. 5-step analysis for determining whether a conflict exists. Establishing one, that the individual is a municipal officer or employee. 2, is there a contract with the municipality? 3, does the officer or employee have an interest in the contract? 4, the officer or employee has the power or duty under this section to enter the contract. And 5, is the officer or employee covered by any of the exemptions? If one or more of the exemptions apply, the contract is not prohibited, but disclosure may be mandated and recusal may be required under the common law or advisable as a matter of common sense. So just because a contract is permitted by virtue of a exception, it should still disclose the existence of that relationship. Disclosure of interests. If you have or will have an interest in any actual or proposed contract or agreement with the municipality, you must publicly disclose that in writing to the governing body as soon as you have interest, and that written disclosure will be made a part of the record by that body. So disclose, 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 even if you think the issue is exempt. Whenever a matter requiring the exercise of discretion comes before a municipal officer or employee, as a member of the board, and disposition of the matter could result in a direct or financial or material benefit to himself or herself or a relative or any private organization in which he or she is deemed to have an interest, the municipal officer or employee shall disclose in writing the nature of that interest. And this is from the model code and most likely is present in your municipal codes. That disclosure should be made as soon as the matter requiring disclosure comes before the officer or employee, or when the officer or employee first acquires knowledge of the interest that requires disclosure. In all cases, well, in cases other than elected offices, the disclosure shall be filed with the person's supervisor or the municipal officer, employee, or board having power to appoint that person's position. So in all likelihood for planning and zoning board members, that would be the municipal board that appointed you, the town board or village board of trustees. And to the extent you're on a municipal board, planning or zoning, a copy of the disclosure will be filed with the board on which you sit. Recusal and abstention are not required with respect to any matter which comes before a board when a majority of the board's total membership would otherwise be prohibited from acting by Section 6 of this code. So if everyone has a conflict, then no one has a conflict. Essentially, the board still needs to be able to do its business. And it's not required with respect to a matter which comes before a municipal officer when the officer would be prohibited from acting by Section 6 of the code, and the matter cannot be lawfully delegated to another person, such as an alternate board member that would be appointed. Effects of violating the law for Section 804. Any contract willfully entered into by or with a municipality into which there is a conflict of interest is null, void, and wholly unenforceable. Payment is not allowed to be made on the contract, regardless of whether or not services were delivered under that contract. It's as if the contract was void ab initio and has no force or effect. Municipal officer or employee who willfully and knowingly violates those provisions of the law shall be guilty of a misdemeanor. And under the Model Code of Ethics, any municipal officer or employee who violates the code may be censured, fined, suspended, or removed from office or employment in the manner provided by law. Other prohibited conduct. Gifts, here we go, everyone's favorite topic. Under the general municipal law, you may not solicit any gift, accept or receive a gift over $75 in value, directly or indirectly, where it could be reasonably inferred that the gift was intended to influence the receiver. 2, could be reasonably expected to influence the receiver in the performance of his or her official duties. Or 3, was intended as a reward for any official action on his part. So that means before or after something is in front of you, you should really not be accepting any gift at all. I know there's a $75 threshold. Err on the side of caution. It's best not to exchange anything of value with anyone who has an issue before your board. The Model Code of Ethics takes a slightly stricter approach. They actually express the $75 as an annual aggregate limit. So somebody cannot give you a bunch of gifts over the course of the year that add up to more than $75.
Hey, Robin, there's a question that came in that I missed, but really to the last topic of recusal. I think it goes beyond that, but the question is, what if a board member lives in a location that is being affected by development and has publicly stated that the project will adversely affect property values?
Yeah, that's a great question. That comes up a lot, particularly where there's controversial development in a particular area where somebody has spoken out against a project, whether it be in the context of a formal public hearing or just otherwise letters to editor of the newspaper, postings on Facebook, postings online. To the extent somebody has taken a vocal position against a project, they should be recused. They should recuse themselves from that project. If they don't, then there's the potential for somebody to claim that that board was not objective in its consideration of the application. So if a person is, obviously every board member comes to a board with a particular philosophy as to what's appropriate for zoning, be it generally characterized as pro-development, anti-development, what have you. There's a distinction between a generalized philosophy as to how you approach interpreting and applying the code versus having taken a vocal position against a project. To the extent you've taken a position against the project, you shouldn't be considering it. And really, if you're going to be taking vocal stances against projects and doing anything other than interpreting and applying facts in as objective a manner as you can, you really should not be on that board. Frankly, it could be counterproductive to your interest because there have been successful challenges on the part of applicants whose applications were denied, and they've asserted that the board did not objectively and fairly consider the application. So it's critical that at all times you remain independent and objective. Do you have anything else, Mark?
No, just a question related to the current topic of gifts.
Mm-hmm.
The topic of Christmas baskets came up. Your advice was that they shouldn't accept anything,
But if you do get a Christmas basket, what should you do with it?
Christmas basket under $75 is fine. I believe there are provisions which in the law which allow for typical standard gifts that would be given at birthdays or holidays. If you're getting a basket from somebody who has an application in front of you, I really don't think you should accept it. But generally speaking, those types of things where there's clearly no reasonable inference that the gift was intended to influence you, then it's okay. And here, I won't read this, but the gift is essentially anything of value. A gift to a municipal officer or employee is presumed to be intended to influence the exercise or performance of his or her official powers or duties when the gift is from a private person that seeks a municipal action involving the exercise of discretion by or with the participation of the officer or employee. And that's the point I was trying to make before. To the extent they actively have something before you, your guard needs to be up just that much higher. And a gift to a municipal officer or employee is presumed to be intended as a reward for official action when the gift is from a private person that has obtained, past tense, obtained municipal action involving the exercise of discretion by or with the participation of the officer or employee during the preceding 12 months. So just understand that there's a presumption that that gift was made to influence you even for up to and including a year after that approval has been given. What is not a prohibited gift? And here's where that question comes into play. One is a gift made to the municipality. Two, gift made to the person who has a pre-existing family or personal relationship when the circumstances make it clear that it's a personal relationship that's dictating the giving of the gift as opposed to that person's status as a officer or employee. Here, the Christmas question, number 3. Gifts given on special occasions, such as marriage, illness, or retirement, which are modest, reasonable, and customary. I think special occasions would also include holidays, provided that gift is modest, reasonable, and customary. Again, I would be extra cautious of not going over the $75 threshold to the extent that the person giving that gift has a matter before your board. Unsolicited advertising materials are not included. Awards and plaques having a value of $75 or less if they're publicly presented to you. So make sure that plaque you get for your years of service and other good service to the community is cheaper than $75. And meals or refreshments provided when a municipal officer or employee is a speaker or participant at a job-related professional or educational conference or program, and meals or refreshments are made available to all participants. Unfortunately, because we do this online now, none of us are getting food or drinks any longer. GML 805A, prohibition against certain actions. We talked about this earlier. You cannot disclose confidential information acquired in the course of your official duties. It's very possible that applications could include confidential material that's labeled as such by applicants. Just think, was something submitted under a claim of FOIL exemption when it was made? If so, it's your obligation to maintain that information as confidential, and you have a duty of care with respect to that information. 2, you cannot receive or enter into any agreement or express or implied for compensation for services to be rendered in relation to any matter before any municipal agency of which you are an officer. And I apologize for the gender specificity here. That's how the law was written. Member or employee or of any municipal agency over which he has jurisdiction or to which he has the power to appoint any member, officer, or employee. 2, receive or enter into any agreement, express or implied, for compensation for services to be rendered in relation to any matter before any agency of his municipality where his compensation is to be dependent on or contingent upon any action by such agency with respect to such matter, provided that this paragraph shall not prohibit the fixing at any time of fees based upon the reasonable value of the services rendered. I think the takeaway here for members of planning and zoning boards of appeal is that you cannot appear before your board on behalf of any applicant and thereby receive compensation for doing so. Any person who knowingly or intentionally violates a section may be fined, suspended, or removed from office or employment in the manner provided by law. Examples from Attorney General's opinions. Donations received by a municipal officer to pay legal fees incurred in pursuing a court proceeding against another city official are gifts. Gifts are very broadly defined. A town planning board member who is also a geologist in the private sector may not be compensated or enter into an agreement to be compensated for soil borings on a project before the planning board. 3, the chair of the planning board who was employed by a real estate company that would receive business if a subdivision application is approved should not participate in consideration of the application. This bears directly on the hypothetical that was mentioned earlier, and consistent with what I said, to the extent that the company is going to receive business and it's known prior to the subdivision application is approved, or perhaps even if it's reasonably anticipated that that company will get business, should not participate in consideration of the application. And finally, a licensed architect who sits on a zoning board should not represent persons making their initial application before the local building department, given the fact that application before the building department might well proceed to the zoning board, which would create a conflict with that architect's role on the board. Do we have any questions before I move on, Mark? I see some popping up.
There were some, but I'm not sure if they're, I think you addressed the holiday basket one, and there was one about, I think the crux of the question is how to get intelligent planning board members. Wants to know to keep their emotions out of decision making.
Yeah, that's a very good practical question, and it's different for every municipality, and it really, unfortunately, bears on how I started the presentation in terms of this being hard work and thankless work and work that frankly not a lot of qualified people want to do because of the criticism that they're going to face. So to the extent it's a sad commentary on where we are in society now, unfortunately, I think the pool of qualified people in some municipalities, particularly those with small populations, can be quite restricted. So I think that's just all the more reason why we need to put emphasis on kind of restoring the respect and dignity that's accorded to public officials who are donating their time to do these things. But we're not going to solve that here. Disclosure in certain applications under GML 809. These are things that aren't necessarily prohibited, are prohibited, but require disclosure, and particularly relevant to ZBA and planning board members. So every application for a variance, amendment, change of zoning, approval of a plat, exemption from a plat or official map, license or permit pursuant to the provisions of any law constituting zoning and planning regulations shall state the name, residence, and nature and extent of the interest of any state officer or any officer or employee of such municipality or of a municipality of which such municipality is a part in the person, partnership, or association making such application, petition, or request to the extent known to such applicant. So an applicant can't hide behind or can't hide the involvement of a municipal or state official merely by having an LLC set up or a partnership set up or some other business entity. To the extent that there's a public official that's behind that entity or a part of that entity, it need be disclosed. And also for the purposes of the section, an officer or employee shall be deemed to have an interest in the applicant when he, his spouse, or their brothers, sisters, parents, children, grandchildren, or the spouse of any of them is the applicant, is an officer, director, partner, or employee of the applicant, or legally or beneficially owns or controls the stock of a corporate applicant or is a member of the partnership or association applicant, or D, is a party to an agreement with such applicant, express or implied, whereby he may receive payment or other benefit, whether or not for services rendered, dependent or contingent upon the favorable approval of such application, petition, or request.
One question came in, Rob,
Yes.
which I think is a pretty easy one to answer. If a planning board member recuses themselves or discloses themselves in relationship to an application, can they speak before the board as a regular citizen about the same application?
Yes, everyone in the community is entitled to speak on an application. A board member does not forfeit their ability or forfeit their role in the community that they have just by virtue of their membership on the board, provided they have appropriately recused themselves. That said, they should be counseled to be careful in what they say, because to the extent that whatever they say could be construed as a broader commentary on how the board should review applications beyond the immediate one that they're commenting on, they should be careful not to evidence any bias against a certain class of applications or nature of activity that the board is considering. So if there are no further questions, I have a few slides here on some sections of the Model Code of Ethics that we have not yet covered. As I mentioned earlier, municipalities are required to adopt codes of ethics. I come across some frequently, or I should say from time to time, that do not have them. Please make sure you have them. Check your code, because I can't cover all of what local codes might include in this presentation. Financial disclosure requirements, they're not in the model code, but I've seen some municipalities that have adopted very broad financial disclosure requirements that operate as a predicate for membership on boards, whereby at your initial appointment to a board or perhaps annually thereafter, you have to file extensive financial disclosures, identifying what businesses you have an interest in, what property you have an interest in the town, all in furtherance of assisting the local board of ethics in determining whether or not, or creating a record as to whether or not you have a potential conflict in applications that come before you. So this is a requirement in some towns, but not all. Prohibition against using position for personal or private gain. We touched on this earlier, but and this goes to the basic fiduciary duty that you all hold. You hold the position of a planning board or zoning board members to serve and benefit the public, not to serve and benefit yourself. So to the extent you are gaining any personal pecuniary advantage from being on the board, that would be prohibited. You certainly can't use town property for personal or private use unless it's used in the same manner that's allowed by everyone. And limiting travel expenses to that which is necessary is always appropriate. Use of municipal resources. We don't have to go through this in detail, but it should be done only as authorized by law and pursuant to whatever municipal policy your government has. The thought being that just by virtue of your position as a board member should not afford you any advantages that others do not have. Interest in conflict with official duties. No municipal officer or employee may acquire certain investments. Any investments that can be reasonably expected to require more than sporadic recusal and abstention under Section 6 of the code. I touched on that earlier when I dealt with the issue of whether or not a real estate professional should be a planning board member. To the extent that person can foresee many conflicts with a board, or to the extent a person has extensive property holdings within a small municipality and is attempting to sell and develop or otherwise obtain approvals for those properties, they should not be a municipal officer or employee or board member, more specifically in that instance. Two, investments that would otherwise impair the person's independence of judgment in the exercise or performance of his or her official powers or duties. But these things should not prohibit a municipal officer or employee from acquiring certain assets, real property located within a municipality and used as his or her personal residence. Obviously, you should be able to live in your community. If you have less than 5% of the stock of a publicly traded corporation, that's not an issue. Or bonds or notes issued by the municipality and acquired more than 1 year after the date the bonds were originally issued. Private employment in conflict. You shall not engage in any private employment, including the rendition of any business, commercial, professional, or other types of services when the employment can reasonably be expected to require more than sporadic recusal and abstention pursuant to Section 6, can reasonably be expected to require disclosure or use of confidential information gained by reason of serving as a municipal officer or employee, or violates the referenced sections of the GML. Bottom line here is that if your business is too close to that of which the board is engaged in, it's most likely in conflict with your official duties, and you should not be on the board. Future employment is also impacted by virtue of your position on the board. You may not ask for, pursue, or accept a post-government employment opportunity with any person or organization that has a matter requiring the exercise of discretion pending before your board, either individually or as a member of the board, both while the matter is pending or within 30 days following the final disposition of the matter. That said, there is also a 2-year ban after you've served as a municipal officer or employee. You may not represent or render services to a private person or organization in conjunction with any matter involving the exercise of discretion before the board that you were previously on for 2 years. And there's a C is a lifetime ban against serving as a municipal officer or employee representing a person who had a matter before the board on that specific matter. So you have a lifetime ban from serving in connection with any matter, from representing or rendering services to a person or organization in connection with a matter in which you substantially participated while serving as a municipal officer or employee. So you can't be involved in the same manner on a lifetime basis. Political solicitations. You shall not directly or indirectly compel or induce a subordinate officer or employee to make or promise to make any political contributions. And you may not act or decline to act in relation to appointing, hiring, or promoting, discharging, disciplining, or in any manner changing the official rank, status, or compensation of any municipal officer or employee on the basis of giving or withholding a contribution. Not a major concern for planning or zoning board attorneys. Confidential information we've discussed already. Boards of ethics. A municipality may have a board of ethics, or a county may have a board of ethics. Those boards are particularly valuable to the extent that they're empowered to render advisory opinions to officers and employees. That's the board you should be going to ask some of these questions that have been posed hypothetically today that I've given some thoughts on. Those boards are empowered to seek their own legal counsel. So not only does your planning or zoning board hopefully have their own respective legal counsels, but those boards of ethics typically have their own legal counsel as well that the board can consult on evaluating questions like these. And the boards also make recommendations with respect to the drafting and adoption of the Code of Ethics itself and the amendments and the rules that flow from that. I have a few cases to discuss before we wrap up here. Tuxedo Conservation v. Taxpayers, or excuse me, Tuxedo Conservation and Taxpayers v. Town Board of the Town of Tuxedo. There was a 3-2 vote approving a development project where the decisive vote was made by a town board member who was also a vice president of an ad agency that had for one of its clients the parent company of the developer. The second department invalidated the town board resolution approving the project. Although Section 809 requires only disclosure but not recusal, this court extended the section to mandate recusal as well, even by classes of individuals not encompassed by the section. Zagaros v. Conklin. These were the efforts by O&R to obtain municipal approval for the construction of several structures necessary to effectuate conversion of 2 oil burning generating units into coal burning units. The proposed required use and area variances from the ZBA and the development permit from the town board. Several members of O&R were members of the public bodies. The ZBA approved the application 5-2. There was an Article 78 proceeding where residents challenged the issuance of the variances. The court set aside the vote on the ground that because 2 of the 5 ZBA members who had voted in favor of O&R's application were employees of O&R, and thus the proceeding was tainted by an improper conflict of interest, even though those members had disclosed that they were employees, and the planning board vote was set aside for the same reason. Do one case study here and then take questions. excuse me, the town needs an environmental review for a park project. After competitive bidding, a contract is awarded to a firm whose primary stockholder, who owns 33% of the firm's stock, is a town board member. That board member did not participate in the board's discussion and vote on the contract and will not perform any of the actual work under the contract. Does that member have a prohibited interest? If so, why? If the board member does not have a prohibited interest, are there any other issues that should concern the board member? This is a chief example of a prohibited interest in a contract. We have a contract between the town and the engineering firm. The town board member in question is deemed to have an interest in the contract because of his virtue of by virtue of him being a 33% stockholder in the engineering firm. As a town board member, that person has Section 801 powers and duties in relation to the contract, the power to approve the contract and to audit claims under it. And there's no exceptions. It's not a pre-existing contract. The trustee owns a third of the firm's stock, well above the 5% threshold that would be considered minimal. Because the trustee's interest arises from its status as a stockholder, the fact that he is not performing any of the actual work is not relevant. And the board member's interest in the contract is prohibited because he has 801 powers and duties and none of the statutory exemptions apply. Even if he abstained from participating in the board's discussions, his interest in the contract would still be prohibited. It's the existence of the duties under Section 801, not whether or not that person actually exercises them, that causes the interest to be prohibited. And there's no statutory exception for recusal and abstention. So we're coming up on our final few minutes here. I wanted to leave a few minutes for any additional questions as well as anything that might be in the queue now, Mark.
Sure. We'll do the rapid fire question and answer session. So the first one is, when a board member recuses, should they leave the room so nobody can see how they react to the presentation?
If you think you can't control your facial expressions or your reaction, perhaps there's no obligation to do so. I do like to advise my board clients to step back from the dais so they're not sitting there, so they're not creating the perception that they're still with the board. But I think going back and sitting in the back of the room, provided they're not going to get into hysterics over what they're hearing, is fine.
So here's a scenario. An engineer with a firm in the municipality sits on the planning board. Is there a conflict with them reviewing site plans prepared by their local competitors? Maybe they prepared a bid for those plans. Is that a conflict?
Oh, that's an interesting question, one that I haven't thought of before. Certainly to the extent that they had a competing bid against the other engineering firm, I could see where somebody could claim that that was a perception of there being an impropriety. Frankly, if you're a professional, if you're a lawyer or an engineer and you want to serve on your local planning or zoning board, I think you should be relatively confident that you aren't going to have a fair amount of business or really any business in that municipality, because the chance for a conflict, whether direct because of your actions or whether tied up in some potentially ridiculous scenarios as expressed here, where somebody could assert a claim that you're trying to give your competitor a hard time, just creates too much of a potential for there to be an appearance of impropriety, and that person shouldn't be on the board. If their town is a small town, it's remote, and the type of work they do really doesn't go on in the town, then it's less of an issue.
Next question. If a board member participates in a discussion about a project, but then recuses themselves at the time of the vote, is that an issue? And what's the difference overall between recusing yourself and just abstaining from the vote?
A recusal should happen at the earliest possible instance when that person realizes that there's a potential conflict. If that arises after there have been some preliminary conversations, I don't think that's an issue. Again, provided the recusal happens at the earliest possible time after learning of the need to recuse or abstain. In terms of the distinction between recusing and abstaining, I think they're synonymous. I think a recusal is a recusal. We have to be careful not to over abstain when there's no reason to abstain, just because it might be convenient for reasons other than there being the need to actually recuse yourself. Because if you're, again, abstaining too much or recusing or abstaining for unjustified reasons, it harms the board's ability to do their job.
Next question. So what if your neighbor has business before the planning board or zoning board? Do you have to do anything? Do you have to do any disclosure?
So there's no default rule there. I think if it is an immediate adjacent neighbor, it's a matter of good practice to disclose the fact that it's your neighbor. In terms of whether or not you need to recuse, the standard is whether or not you think you can be objective. It's probably safer to recuse yourself if it's an immediately adjacent neighbor. There's no rule requiring you to so recuse, but just be extra cognizant of the fact that you need to be objective if it's somebody who lives within close proximity to you. Chances are, if you're within the zone of neighbors that was required to be noticed as part of a public hearing related to the application, you should think very long and hard as to whether or not recusal is appropriate.
Next question. Would these ethical considerations apply similarly to planning and ZBA consultants, like legal consultants, engineering, or do those professions apply their own ethical standards to these situations?
Well, those, as a lawyer, I have my own ethical standards that I have to abide by. If I were sitting as a board member, I would have to abide by both my ethical obligations as an attorney and the GML provisions related to municipal officials. And Mark, I imagine that would be the same for planning professionals as well.
Right. And the next question, can someone abstain from a vote without any apparent conflict of interest? They just don't want to vote on the record. I would call them a coward. You're sitting in the seat to do the job.
Yeah, you have to do your job. So we can't have any sham recusals, and that's up to your own conscience and board members policing themselves and making sure that that does not happen. But that's not a legitimate reason to recuse.
Great. Well, I think we've gotten through all the questions in the Q&A. I'd just like to take this opportunity to thank Robert for his excellent presentation and overview. I will be posting these slides and the copy of the presentation on the conference webpage for viewing later. And as always, you can reach out to us with any additional questions, and Robert's contact is available too as well. Our next session is going to happen on Friday, the wrap-up session for our October conference here. So thank you all for attending the conference sessions. Our wrap-up session will be at noon on Friday about scenario planning hosted by Bergman Associates. So with that, I'll let you all go. Have a great afternoon.
Thanks, everyone.